I'd like to take a moment and talk about the handshake deal. My word is my bond. In all except for a few circumstances, a handshake deal is a real deal. There are exceptions. Land, can't do that. Big deals. But in a lot of cases, a handshake is a real deal. What if the other person forgets the deal? What if the other person changes their mind? You can go to court. You can enforce a verbal contract if you can prove it. The problem is if you're going to court, you've already got somebody who's probably not agreeing to the deal. And you're going to have to leave it to a judge or a jury to decide who they believe. If it's important that you make a deal that people honor, put it in writing. If it matters whether or not somebody does what they say they're going to do, have a lawyer put it in writing. There's good reason for this. First, if you're going to go to court, we're the ones that are explaining to the judge, explaining to the jury, why the contract needs to be enforced. We already understand what the judge is going to look for, what the jury is going to look for, and those terms that will be important in order to make sure that you get the benefit of the deal that you made. You can write down what you think the deal is, and you might do a pretty good job. But there may be those important parts that you don't remember that make all the difference. What I've found is that when presented with documents, the people making the deal at the outset, for many different reasons, they're busy, they're not paying attention, they're focusing on the highlights, they'll make assumptions about the documents, and they'll move forward based on their assumptions. The tragedy occurs when they find out that their assumption was wrong. If it's important, wouldn't you want to know beforehand if your assumption is correct? If you've got a deal, if you care at all that the other person sticks to it, come down and see us. That's what we do. We'll help make sure that you get a deal that everybody sticks by.